37% of small businesses were hit with an employee lawsuit last year. And here's the thing most of those owners had in common: they thought they were in the clear. They had a real reason. They were in an at-will state. They just didn't know what they didn't know. If you're a small business owner with employees, firing someone is one of the highest exposure moments you'll face. One missing document or one thing said in the wrong tone can turn a legitimate termination into a lawsuit you'll spend $30,000 defending, even if you win. This video is the framework I wish every small business owner had before that conversation. Let's get into it. First, the most important thing I can tell you about wrongful termination lawsuits: they usually aren't about the law. People don't sue their boss because the law was broken. They sue because they felt treated like garbage. That one insight changes everything. The biggest mistake small business owners make is thinking the process starts the day you decide to fire someone. It doesn't. It starts weeks or months earlier, and if you haven't built a paper trail before that conversation, you're walking in exposed. Step 1. Verbal warning. Documented. Not just a conversation, a note in the file with the date and what was discussed. Step 2. Written warning. Specific, factual, no emotion. What the standard is and what improvement is expected. Step 3. Performance improvement plan or final warning. Clear statement that continued failure will result in termination. Step 4. Termination. At this point, the employee should not be surprised. It should feel like the next step in a process. None of this applies to serious misconduct, theft, harassment, violence, where immediate termination is appropriate. Before any termination, run through these 3 questions. If any answer is yes, stop and call an attorney. Question 1. Has this employee recently reported anything: harassment, discrimination, or a safety issue? If you fire them now, the timing alone creates a retaliation narrative that's very hard to overcome in court. Question 2. Are you in a protected class situation? If the employee is over 40, pregnant, or disabled, you need a review. Question 3. Have you or any manager ever been rude? Remember, people sue when they feel treated like garbage. The termination meeting itself is where most owners go wrong, either by saying too much or by being too cold. Keep it short. The decision is already made. This isn't a debate. State the reason clearly and don't ramble. Be direct but humane. State that performance hasn't improved and today is their last day. That's it. Never say "I've been wanting to do this" or talk about their character. Keep it to documented behavior only. Always have a witness and have the paperwork ready: termination letter, final paycheck, and property checklist. What you do immediately after matters. Revoke system access before or during the meeting, not after they leave. Lockdown documentation. Every warning, every email, every note should be preserved and backed up that day. Brief your team carefully. Don't give details. Anything beyond "they are no longer with the company," risk a claim. Here's where the situation looks very different for businesses working with a PEO. When you have a PEO, their HR consultants are part of your team. They help you build documentation habits early. When it's time to terminate, you call your advisor. They review documentation and walk you through the meeting structure. Some POs also include employment practices liability insurance, which covers your legal defense costs if a claim comes. PEO Marketplace is the independent platform that helps you find the right provider. We vetted over 100 options. Our AI tool, Paul, can walk you through the whole process before you talk to anyone. Link is in the description. If this helped, subscribe. We cover real situations every week. If you have a question, drop it in the comments.